All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good afternoon. This is the time set for oral argument in our cause number CV20140001, Stasinski versus Lindahl et al. Counsel, we are recording today's proceedings, so when you step to the podium, please identify yourself and the party that you represent. Each side will have 20 minutes for argument, and the appellant, Mr. Jacobson, you're responsible for watching the clock and reserving any time for rebuttal that you might desire. We have read the briefs. We've conferenced the case prior to argument. And with those preliminaries, Mr. Jacobson, you may proceed.
Good afternoon. May it please the court, my name is Jay Jacobson and I represent the Stasinskis in this matter. I plan to address the Sabin versus Roush case first, unless the court would like me to do something else. I'd be happy to address any issues at any time. Upon reading that case, it's my interpretation that the case does provide meaningful guidance to the issues raised in this case in three respects. First of all, it discusses the applicable general principles of the duty of a seller of real estate to convey marketable title. On page 279, the Arizona Supreme Court held the general rule is that it is implied that the seller will convey a marketable title. That is one of our main contentions in this case, is that we did not receive a marketable title.
So can you never have a marketable title when you have a prescriptive easement?
Pardon me, sir? Your Honor?
Can you never have marketable title if you're dealing with a prescriptive easement?
It is our contention that if a buyer is buying property and the seller is selling property and access to that property is based on a prescriptive easement, that is a required disclosure. And if it hasn't been adjudicated yet by a tribunal, that it is an unmarketable title because it's going to require future litigation to establish the scope and boundaries
Let's talk about the prescriptive easement. The facts here is that the Lindahls had been using that road since, 1952, 1953, almost my entire life. They had a prescriptive easement from Mr. Moore. His lawyer said that back. Mr. Brown said that in letters. There was never any dispute over it except as to the width, and they resolved that. So I don't see anywhere in which you have raised on appeal any argument that there is no prescriptive easement. So the position that we are faced with on appeal is that there was, in fact, a prescriptive easement. So getting back to Judge Howell's question, when, in fact, as a matter of law, there's a prescriptive easement, is it your position then that that means, nevertheless, the title is unmarketable?
A prescriptive easement would only exist after there's been litigation and a final judgment.
That's not, that itself is also incorrect as a matter of law. We don't have to have litigation for a prescriptive easement to exist. We have case law that says it is, in fact, adequate and good title. Now,
Okay.
if there's a dispute, maybe you have to deal with it, but you can convey property with a prescriptive easement. That's called adverse possession in this state.
Okay. Your Honor, if the Lindahls intended to convey a prescriptive easement to us, it's our position that that was a required disclosure. It's a material fact that sellers would have to disclose. It's material information. And my clients have submitted affidavits saying that if that disclosure had been made, they would not have gone forward with this transaction.
But your clients had access to this property every day that let's talk about the Lindahls' property first before we get to the Havens. Every day they owned it until they lost it through the foreclosure. They had access to it. It was not landlocked.
It was with permission of the one of the property owners, and that's Trace Moore of Indian.
That's because he had granted the Lindalls a prescriptive easement. He acknowledged that, his lawyer acknowledged that.
Again, our primary contention, Your Honor, is that that was required to be disclosed to my client. Now, the prescriptive easement at issue doesn't even reach my client's property anyway. There is a 216-foot gap that exists between...
No, the prescriptive easement reaches your property. It's the recorded deed that arguably is maybe 216 feet
Right.
short. Okay? But the prescriptive easement that the parties intended and lived with since about the time I was born went right to the property line.
Well, it's our position that that fact is material. And my client should have had the opportunity to make a decision as to whether they wanted to buy property whose easement was based on prescription. I would like to draw the court's attention to the seller's property disclosure statement, which was originally submitted in the in the defendant's statement of facts, the ones that move for summary judgment. It's Exhibit 1 to our appendix. And the introductory language of the seller's property disclosure statement, this is a very common document in Arizona. It says, sellers are obligated by law to disclose all known material important facts about the property to the buyer. The SPDS is designed to assist you in making these disclosures. If you know something important about the property that's not addressed on the SPDS, add that information to the form. Prospective buyers may rely on this information you provide. And then skipping ahead one sentence, it says, by signing below, you acknowledge that failure to disclose known material information about the property may result in liability. The basis of access is material information to all buyers of property.
Well, let's assume for the moment that we agree with you. I'm sorry, where I struggle with this case, and we've all struggled a little bit, I think, on this, is where is the damage? Where is the fact of damage here?
Okay. Well, my client, there was 3 parcels involved.
Right.
They still own 13 acres today.
Talk about the 431. Where is the fact of damage?
Okay.
And then we'll talk about the Havens 13 in a moment.
We have submitted 2 damage reports. They're Exhibit 7 and 8 of our appendix. 7 is the damages our expert CPA, Leroy Gaintner, prepared, and these were submitted.
He assumed it was landlocked. All of the experts assumed the property was landlocked.
Okay. My client would not have purchased this property had he known that the easement was based on prescription.
And how did that harm him?
Well, he made investments over the years in that property, and this is it's like if all material information is disclosed in connection with an investment, and the facts are that the buyer would not have made the investment had that material information been made known, they would invest in a different direction, and that is addressed in our Exhibit 7 to our appendix.
But they had the property, they used it day in and day out, they used that road, then they lost the 431 and the 10 because of a foreclosure. Under those unique circumstances, where are they damaged? They lost the property because of a foreclosure, not because the easement was prescriptive.
There's also one buyer, there's one in the record, and we addressed this at oral argument below. The defendant's experts, John Latardo, acknowledged in his affidavit, this is their expert, that there was one buyer of the property who made a written offer in excess of $4 million on this property, and then later backed out during the due diligence period because he had concerns about the clouds on title concerning the easement or the lack of access, and the fact that he didn't know there was some uncertainty regarding the easement. And this is...
Isn't that hearsay? How is that admissible evidence on summary judgment?
The expert, John Latardo, defendant's expert, has stated that as one of his basis for his opinion. He relied on that information, and that's one of his opinions.
That goes to damages. How does that go to, that's their expert decision. How does that go to your case?
Lost profits. It was a $4 million written offer that we lost out on the sale due to concerns over the easement of the buyer.
I seem to recall that the actual statement was that there was some concern, but it wasn't the only reason.
Well, we attached John Latardo's affidavit. We talked about it during oral argument, just like I have here, Your Honor. And Exhibit 9 of our motion for reconsideration attached the defendant's expert's affidavit. And in
But
paragraph...
Forgive me, this fellow only suggested that he decided not to go through with it. There's not even clarity that he even made an offer on this.
Yeah, he did make a written offer, Your
Well,
Honor.
where is that in the record?
Yeah, Exhibit 9 of our motion for reconsideration, paragraph 15, which page 3. This is the
Let's stay away from your motion to reconsider,
Okay.
okay? Let's stay away from that. Let's talk about the evidence before the trial court, when the trial court entered summary judgment. Let's talk about that evidence. Where in the record before the trial court on summary judgment is there evidence of this?
Okay, on page 51 of the transcript from the hearing of September...
That's not evidence, that's argument. Where is the evidence? I want to talk about the evidence, not the argument.
I raised this fact at the oral argument, and none of the defendants objected to that.
Excuse me, that's argument. I want to talk about facts and evidence in the record.
Okay. The evidence we submitted in response to the motion for summary judgment is Exhibit 7. It's Leroy Gaitner's expert report on damages, where he states that the damages are $1.5 million.
Because
He would not have invested in this property. He would have invested in alternative
That's not what Mr.
properties,
Gaitner's-
other properties that would have qualified for the 1031 exchange.
But doesn't Mr. Gaitner's report assume that the property's landlocked?
Yes.
but it's not landlocked.
It's the recorded easement. Again, the SPDS, it is, Your Honor, landlocked because the recorded easement that was.
So your clients were never able to never get on their property for all that time?
My clients had verbal permission from the adjacent property owners. It was permissive use.
Excuse me, where in the record is that? Where in the record, the evidence given to the trial court on summary judgment, not the motion to reconsider, on summary judgment is that your clients had permissive use?
In the trial transcript from the September 4th hearing, we discussed that.
But that's argument. Where is the evidence in the record by way of affidavit, declaration,
Okay.
deposition testimony?
Your Honor, the damage report is based on my client's affidavit, which is in the record, saying that he would not have bought this property if these facts had been disclosed to him. If the sellers, remember, everybody thought that the quitclaim deed for grant of easement reached the property and was valid. That's what was attached to the SPDS form. It's basically a case of mutual mistake. The sellers believed that that easement reached the property. My client was represented in the SPDS form here that it reached the property, and later it turned out that that was not the case.
But they had, at the very least, they had a prescriptive easement for the 216-foot gap.
There's a right, the recorded easement document, which was attached to the SPDS form.
So
That's the one that has the gap.
So that would be odd because you're saying that there was a recorded easement that was 216 feet short.
Correct.
And then they had a permissive use for the 216 feet?
Yeah, the Trace Moore, the owner of the adjacent property, did not prevent my client from using the property.
I could be misreading the record.
Until 2010, my client thought the recorded easement reached the property and was valid.
My reading of the record, and I could be misreading it, but I thought Mr. Moore acknowledged there was a prescriptive easement for that.
His attorney, I believe, Gil Shaw, there's a letter that was produced in the defendant's joint statement of facts. That letter was never disclosed in the real estate transaction. This is all after the fact. These are the court. We've all purchased property. If it is important to a buyer to know the basis for access, that's required to be disclosed by the sellers in the seller's property disclosure statement. Again, if at any time the Lindals had stated that the easement to reach the property was something other than what was being attached, which was the quitclaim deed for grant of easement, they would not have bought the property.
What do you make then of the argument that your clients are deemed by operation of law to have notice of the information conveyed in this recorded easement, and that on its face, when you look at the diagram of the road, it shows where the cattle guard is, and that is apparently where the easement, the recorded easement ended. Thus, your client would have been deemed to be on notice that there was a gap.
Okay. Anytime, that statute is not meant to undermine the promises between the party, the disclosures, the express promises and contractual agreements between the parties, or the duty to convey marketable title. Here, again, I must turn to the property disclosure statement, lines 31 through 37. 37 says, are you aware of any problems with legal or physical access to the property? They say no.
Well, what's wrong with that answer when they had a prescriptive easement for 50-some years?
It is our contention that if part or all of the access to the property was based on a prescriptive easement, that was a required disclosure under property law in Arizona and under the seller's property disclosure statement.
So you are answering my original question that if you have a prescriptive easement, you can never have marketable title as a matter of law.
I believe that this is not a marketable title because litigation, I believe, is required to establish the scope of the prescriptive easement.
But then the answer to this question is yes, that's your position. I mean, you're trying not to say that, but if you're saying that there was the possibility of litigation over a prescriptive easement, that's true with every prescriptive easement. And so aren't you saying there can be no marketable title with a prescriptive
Well, the parties
easement?
can agree and stipulate. If the sellers disclose that the 216-foot gap is going to be closed, so to speak, via a prescriptive easement.
You're conflating that with the prescriptive
Well, no.
easement. You're conflating the quitclaim deed issue with the prescriptive easement, focusing only on the prescriptive easement. What I am hearing you say, which is what Judge House said at the very beginning of the argument, is that a prescriptive easement doesn't convey marketable title, which seems to run directly contrary to Curtis and a number of other cases that say it's a vested property right that runs with the land.
Well, the second part of Sabin, I think, that applies and supports our position in this case is how you define marketable title. Marketable title must be free from any reasonable possibility of future litigation, which must be necessary to remove apparent or real defects, free from reasonable doubt and not clouded. Such a title must appear to be, okay, this is the key language, such a title must appear of record to be marketable. There's no prescriptive easement of record.
That case didn't involve a prescriptive easement. It involved a situation in which there were two recorded interests on the title, so that there was, in fact, clouds on the title as reported by the record. So it didn't involve the situation that we have here, correct?
That is a distinguishing fact.
Okay. And also, the court relied on I think it's an Oregon case, that for that last point. But that Oregon case was where the parties had agreed to convey good title as shown on an abstract of title. So that's a difference too, isn't it?
The prescriptive easement at issue in this case was never disclosed to my client. It is a material fact under real estate law, and it's not of record.
Forgive me,
never
but I
been
do
recorded.
think that you are kind of conflating. There is, I understand your point about non-disclosure, and we'll come back to that. Getting back to Judge Howe's question, and I think I do understand your position. I think your position is that there can be, as a matter of law, no marketable title conveyed where there is a prescriptive easement or adverse possession. Is that?
It's my position that has to be adjudicated through the Quiet Title Act, because with the third part of this case that applies is that all people with interests in the property must be joined in that case. That was the third part of this case. That hasn't occurred here. And the lower court has ruled that there's a prescriptive easement without stating the scope of it. It's at the request of defendants, none of whom own any interest in these properties. There's two.
The Havens own I guess they don't own it any longer, you're right.
None of the parties except for my clients own property out there. The two other relevant property owners are Trace Moore's property, Indian Rock, and then secondly is the Sachs property, who now own the 431 acres. Their lands would be burdened by any prescriptive easement holding. How wide is the prescriptive easement? Is it 50 feet? Is it 40?
Hasn't that already been established? This
No.
thing's been around for 50 years.
The ruling does not establish the scope of the prescriptive easement. Nor does it, I think this case, join the parties whose lands will be burdened by a prescriptive easement. I have 25 seconds left. I guess I will reserve that for my rebuttal unless there's other questions you'd like me to address.
No, thank you. Mr. Manhart?
Good afternoon. I'm Daryl Manhart, and I represent the Appalese, Lindahl, and Havens. And I guess since my adversary started with Sabin, I'll start with that as well. I think it highlights or allows me to highlight that the claim that the Stasinskis have presented, while wrapped in the rhetoric here of marketability of title, is not in fact one for marketability of title. If you take a look at the phrase there, marketability of title, he's really emphasizing marketability, and he's not getting the point of this is an issue that has to do with title, not the marketability of the property itself. And for instance, if you look at, if you allow me to cite some secondary authority, Amjur second, vendor and purchaser, section 103, which is the first of like 40 sections, all entitled, I forget the title, it's what constitutes good or marketable title. The very first sentence of section 103 is marketability of title is concerned with impairments on title to a property, i.e. the right to unencumbered ownership and possession. So marketability has to do with ownership and possession. And if I can jump to the last sentence of that same section, 103, I want to quote the last sentence. There is a difference between economic lack of marketability, which concerns conditions that affect the use of land, and title marketability, which relates to defects affecting legally recognized rights and incidents of ownership. And there's a footnote for that. It cites a 2002 California case and a 2004 Massachusetts case, both of which include citations to other opinions to that same effect. And what the Stasinskis argue here is that what they're not arguing, which would be a marketability of title, is that there have been any other claimants to ownership or possession of the 431-acre parcel, the 10-acre parcel, or the 13-acre parcel. They're talking about something else, what their perceived economic marketability or utility of the property, which is not having to do with ownership and possession of the three parcels. And I'll borrow from Mr. Stasinski's counsel's own brief, which cites to volume 17 of Williston on contracts several times, including section 50:10, where he has lifted various sentences out of that section in his brief. But if you look at the cases footnoting that same section, it includes the same California case and Massachusetts case that are referenced in the Amjur site, and various others which also make that same distinction, noting that one can have marketable title while the land itself is valueless. There's a reference to a 2011 Vermont case that describes the rule as this way: marketable title is a title that will enable the purchaser to hold the land purchased free from the probable claim of another. The Stasinskis have never come before a court and said someone else is claiming the right to ownership or possession of any of the three parcels.
Let me ask you about Sabin, because I understand everything you've said, but the Supreme Court went on to say that such a title, and the such a title referring to marketable title, must appear of record to be marketable.
Yes, Your Honor.
So what do we make of that?
That's completely consistent, Your Honor. I'd emphasize those last words, of record. And if you look at what's going on in the Sabin case, you started to recite some of the facts yourself earlier. The court is dealing all with things that are of record. They appear to be contracts of sale with a few deeds interspersed in there. So the court was looking at a series where it went from, I think, Stone to Hill. I'm going to miss some names, Nay, Ray.
Yeah.
Okay, thank you.
Don't explain it, that's okay.
Okay, but the part I want to would explain, though, is within that chain you have, when you get to the end, whichever one was the plaintiff, Sabin or Roush, looks back and says, well, in here there's a quick, or not, sorry, I mean, there are deeds to two other people that while they say they're subject to these other contracts, I'm not sure about whether I've got marketable title. Those are all of record. Those all have to do with the rights of ownership and possession of the particular parcel of land there. If you look at the deeds here, the deed for the parcels the Lindahls conveyed and the deed for the parcel the Havens conveyed, the first one lists the 431-acre parcel by legal description and the 10-acre parcel by legal description. It does not list, it does not convey with a warranty of title the easement. Same for the Havens property. It conveys by a legal description of the 13-acre parcel, and I'm not, I don't want to presume the level of experience with real estate transactions, but you may have seen, I have seen where sometimes people convey, as it'll be a parcel, a third, let's say another parcel that lists an easement in and list a legal description for that. You could give a warranty deed as to an easement, but there isn't one here. So the Stasinskis are arguing marketability of title when there's no title claim against the three parcels that they acquired by deed. They're arguing that we think we got something that's less useful to us than we thought, and that's not covered by their warranties under their deed. They have title and possessory rights to all three parcels.
You know, I'm not sure I'm fully comfortable with that argument. It was, and maybe my understanding of the marketable title is too basic, but it was my understanding that marketable title is really just simply the ability of the owner to convey the title, the property, to the next person without having an impediment dealing with the title that would interfere with that alienability of the property. And I thought that's what Sabin and other Arizona cases recognize in talking about marketable title. Am I wrong? Right?
I'm not sure.
Close?
I'm sorry, Your Honor, I was nodding my head, but I don't actually see the difference in what I said and what you said.
Well, okay, so let's assume that I were on the same length then. Then the question is, how should marketable title be memorialized? Now, Sabin dealt with a situation where the clouds on the title were of record. Here, the potential impediment to marketability is access, or lack thereof, arguably. And here, there was a prescriptive easement that came into existence through adverse possession, back starting in about 1953. Okay. That prescriptive easement is not recorded. Well, put aside the deed. But that prescriptive easement, adverse possession, is normally something that happens. It's not recorded. Okay. But Sabin says such a title must appear of record to be marketable. Does that mean then that if you have a right to use a road that has been fully vested through adverse possession, there's no question about that, but it's not a record, that you don't have marketable title?
I'll try to answer your question, but I want to qualify.
I think your answer should be yes, you still have marketable title, but if it's no, then help us.
If one wants to convey marketable title to the easement, then one would have to obtain a judgment and record it as to a conveyance of warrantable title as to the easement.
But no, you got the 431.
Correct.
Okay, if that property is really landlocked, it's not marketable. If it was, as a factual matter, landlocked, it's not marketable. We have cases that say you got to have egress.
Well, Your Honor, landlocked is kind of a loose term, so they have
No way to
ingress
get
and
in there
egress.
unless you're a drone, okay?
Well-
So unless you're a drone, you don't have any way to get into the property, physically get into the property, other than you you fly in there and you land in there.
I'm sorry, I think I'm going to disagree with you
Okay.
on something, Your Honor, and that's that I don't agree that that's a marketability of title issue. You could have a mountaintop lot that has no access except by helicopter. I'm not sure where I know one exists, but there's nothing legally that would prevent one from owning that, having the possessory rights and having their access be limited to helicopter. The fact that it would be landlocked in that sense would not be necessarily a marketability of title issue. You could have other contractual issues, which now I'm going to be hypothesizing what did someone put or not put in that contract. In this case, we have a contract that says, well, I don't even know if I want to go too much into the contract, but and I'm sorry if I'm backpedaling onto other things that you don't want me to talk about, but the seller's property disclosure statement gives them or points out to them the recorded quitclaim easement. That particular document, though, by the way, sellers or buyers counsel today is arguing as if there's some warranty from that. Line 236 of that document specifically says it's information only and no warranty whatsoever is given. Similarly, over into the contract, there's disclosure of the recorded easement on the addendum, but the contract itself has, I think it's around line 280, says there are no warranties except what's in this paragraph, and there's no warranty about physical access within that paragraph. So we don't have any contractual warranties that are issued here. We have only their argument that there's a warranty based upon the deed. And the deed itself, the deed of the 431 acres and the 10 acres for the Lindalls and the deed for the 13 acres for the Havens does not say that it's conveying title to the easement. They got that easement because it was established by prescription, and that one is a vested property right that goes with the land. And they also got, in the case of the Lindall's property, the rights under the recorded quitclaim easement. But they didn't get it by virtue of it being part of that warranty deed. They got it because it's appurtenant to the title they got on the warranty deed.
Forgive me, but I thought there was Arizona case law, but I know there's cases from at least New York and Wyoming that say that lack of legal access renders title unmarketable.
Well, Your Honor, I don't have those cases here, but I know that what you can do is you can get title endorsements over
Well,
that.
let's
but-
leave title insurance out of the fray here.
Well, Your Honor, I think
Okay.
it's relevant to that because it maybe suggests that the reason that there is a title endorsement product available is that maybe the law is not exactly as you're asking me.
Well, I guess we'll have to take a look.
Certainly, and I may be incorrect on that as well, but I did not find those cases when I was putting together my brief here, or I would have felt like I needed to have addressed them.
I guess I'm not now clear on your argument. I thought your client's position was they had conveyed marketable title because the 431 and the 10 and the 13 were all accessible. They were not landlocked.
Oh, Your Honor, that is correct.
Okay.
We deny that the property's landlocked, and the trial judge agreed they're not landlocked. And you heard today, Mr. Jacobson doesn't deny that they've actually had access the entire
Is the
time.
point you're making today is that if we just look at I'll use the 431 by way of example. If we just look at the 431, the warranty deed that went from the Lindalls to the Szynskis simply described the 431.
That's correct.
And because it said nothing about any easement, what it conveyed was marketable title to the 431. It didn't attempt to do anything beyond the 431.
It has an effect beyond that, Your Honor. It did, the rights, the easement rights did go to the buyers when they got that deed.
Mm-hmm.
So I'm sorry if I'm being not sufficiently clear to parse that out. If we're talking about what warranties accompany that deed, the warranties only accompany the specific land described or what's described on the Exhibit A to that document. So the warranty of marketability of title that's implied in the deed only applies to the 431 acres in your example. It doesn't mean I'm saying they didn't get an easement, and it doesn't mean that they did not. They got the easement. But they don't have a warrant they don't have a warrant of marketability of title as to the easement.
I understand your point.
Well, and Your Honors, by various of your questions, you raised another point in your questions to the appellant that could have been my first issue as well, which is damage. Whether we're talking about contract claims, tort claims, any sort of claims, the last element of all those is always damage. And That was one of the issues the trial judge specifically asked about here too. And the plaintiffs have never put on a case showing damage. They have put on experts where there's been an assumption that if the property is inaccessible, what is the value of that property? And then based on those, calculations are made. But in terms of their claim that they've been denied access, they admitted that they used the two parcels from the Lindahls for the whole 5 years they had it till it was lost to a foreclosure for non-payment of the bank loan.
So if they believed that they were getting recorded easement, but what they really got was an insufficient recorded easement plus a prescriptive easement for the difference. Haven't they received less than what they thought they were getting?
Well, no, Your Honor. If I'll separate those out, if I may, too, though. The 431 acres and the 10 acres, they had the entire utility available of that property to them to the entire time they owned it.
Based on the recorded easement or the prescriptive easement?
Well, Your Honor, I'd say it really doesn't matter even if there was no easement. If they were never deprived of access, they had the full value of that property for the entire time they owned it. You could go back and say, what if somebody discovers after the property's transferred 2 more times that the situation they've argued in this case? Can they claim that the property was more or less valuable at the time they owned it?
Well, are you conceding then, at least for purposes of our interaction right here, that they had permissive use instead of an easement?
No, Your Honor. Mr. Jacobson, I don't know that appears any place in the record except at the time Mr. Jacobson was trying to introduce it at oral argument before the trial judge, where he was arguing that they got permission. But there was already an easement established, and there's no fact record to show that they had to get permission, even if they chose to try to make their case look better by going and asking for it.
So there was an easement. So
correct.
My question is the fact that they believed they were getting a complete recorded easement, but they only got a prescriptive easement. Have they gotten less than what they thought they were getting?
Well, Your Honor, if you may be trying to make me answer in a hypothetical fashion, I'm sorry, I'm going to answer in terms of what we have here, which is if the Stasinskis received the recorded document, which they're deemed to have had even if it wasn't handed to them, but they have it before they closed the sale, and if they believe it falls short, or even if they didn't believe it, it was their duty to find out. They have the document. If in fact it falls short, they should have not closed on the sale. By closing, they're deemed to have accepted that the easement goes as far as it shows on that record. So they don't have the ability to come in later and say, we have now realized 4 months after we lost the properties that easement fell short. We don't think we got what we were supposed to.
But is your argument, though, at bottom, that there are no damages because there is no difference in terms of ingress and egress between a recorded easement and a prescriptive easement?
I agree with that, Your Honor.
So
my argument, though, was broader. I'm not sure you were agreeing with me, but my argument is they, in fact, were never denied access, never denied ingress or egress the entire time they owned those 2 parcels, and therefore they had no damage, even if there had been no prescriptive easement and the recorded one does fall short, they weren't actually damaged during the time they owned those properties.
And I guess my only quarrel with that is if they didn't get access because of the easement, then they would have to get access based on a sufferance of Mr. Moore, which would make the property unmarketable.
Well, Your Honor, I don't agree that makes it unmarketable. I understand Judge Norris's question, though, that she believes or is suggesting that there may be cases on whether that would still make it landlocked, but that's not the facts we have here, and no one's ever challenged that easement. And you know what Mr. Jacobson's proposing is basically a rule that would require people who have no dispute over country roads that have been used for years to all run into court and file lawsuits to establish easement rights. These easement, the law is that once it's established by adverse possession, it exists and it's a vested property right, and that happened here. And in fact, we have in the record letter from Mr. Moore's attorney showing that there isn't any dispute. He's not claiming anything to the contrary.
What about Mr. Jacobson's point that around 2006 or so, there was a potential buyer who backed out because he had some concerns over the easement?
Well, Your Honor, I'm not familiar with that unless it's the same party that bought at the after the foreclosure sale.
I can't remember the gentleman's name, but
well, I heard him today refer to Mr. Latardo
that was
who's one of the experts.
Yeah, and
Right.
there is in fact a reference in, I think it's by Mr. Latardo, that the possible buyer who shall not be named right now thought about buying it for a big amount of money, a large amount of money, and then decided that he was somewhat concerned over the state of the access.
Well, Your Honor, that didn't come out of plaintiff's evidence, and there really isn't anything else to support that. But I'd also point out that if I take the other party that did buy at the foreclosure, it's in the record and undisputed that they got title insurance of physical access to the property.
But wouldn't there be possibly damage if there was a potential buyer who backed out because of concerns this was only prescriptive and not of record?
Well, Your Honor, the plaintiff would have to show quite a bit to show that was a transaction. They actually had either a contract or an offer that they could have accepted to establish that, as opposed to the suggestion that somebody might have been interested.
If there's evidence in the record that meets that standard, then is there, at least for purposes of summary judgment, a jury question or a question of fact on fact of damage?
I'm sorry, Your Honor, I'm not willing to concede that because I really don't remember what's in Mr. Latardo's attachment, and I feel like I'm going too far out on a limb.
Well, didn't Mr. Latardo's attachment come up for the first time in the motion for reconsideration?
I'm sorry, Your Honor, I don't recall, and I don't
It would
remember
help
if
you,
Mr.
wouldn't it?
Jake, it would, because my argument is that those certainly were not before the court at the time the summary judgment was
I
granted.
think it was Exhibit 9 to the motion for reconsideration, and if that were true, that wasn't before the court at the time it ruled.
Correct, Your Honor.
Thank you. Your time is up. We're going to give Mr. Jacobson 2 minutes because Mr. Manhart got a little extra
Thank you.
time.
We're going to do a hit and run. And I would like to emphasize that we all learned early in law school that when you're proving your causes of action, the elements of cause of action, duty is a question of law for the court, but breach, causation, and damages are questions of fact for the jury.
Well, the fact of damages is different from the quantification of damages, so I disagree with you
Right.
there, but go ahead.
And on the damages, I would like to, again, emphasize, my client is held with a 13-acre parcel today. It's unmarketable. He can't list it. There's no easement of record that reaches his property. The easement of record falls 216 feet short, and in order to get to the 13 acres, he would also need an easement over the Satch's property. They're not parties to this case, and there's never been a ruling that there's a prescriptive easement or otherwise over a portion of the Satch's property, Kirkland Creek Ranch.
Really? How has that parcel been accessed all these years?
Just people driving over it with the permission of the landowners out there. Again, this is a non-disclosure case. We are suing the Lindahls for not disclosing the facts that were important to us, and marketability of title is from the standpoint, the eyes of the buyer, not the seller and not the court. And we've cited the treatises and cases that stand for that. This 13 acres is a hot potato. My client cannot get rid of it. He owns it today, and he would like to rescind the transaction, give it back to the...
Why doesn't he just send a letter and $5 to Mr. Moore?
It's unmarketable because it requires litigation and costs. And what if Mr. Moore says no? And he should not be required to do this.
This is after his lawyer, Ray Brown, 30 years ago said he had a 431 and a 10 and 13 had a prescriptive
We have no problem
easement.
with the basis for an easement as long as that's disclosed in a real estate transaction. How would anyone feel in this room about buying property and later finding out that it wasn't disclosed in the SPDS or real estate contract or anywhere that the easement to get to the property is at least based in part on prescription? and that the parties whose property are affected by that ruling aren't even parties to this case. The Satches aren't parties. The easement would have to go over their property to get to the 13 acres. Maybe they would disagree that there's been a prescriptive
Well,
easement.
are they bound? They're not parties, so how can they be bound by anything decided?
That's
here?
right, because there's no easement of record.
But in between you and the other side, can't they be bound by this?
They are welcome.
If the issue is marketability of title, as between the two of you, the court resolved the issue. You two are maybe bound, but how does this affect anyone else?
It doesn't run with the land. That's why it's an unmarketable, the title to the easement's unmarketable because it doesn't run with the land. It's, none of the affected property owners have been joined. It's not an easement of record.
Thank you. Thank you both for your arguments. We will take this matter under advisement and issue a ruling in due course. At this time, we will stand in recess in preparation for our next argument. Thank you.